Welcome everyone who has attended this webinar. We thank you for having joined us once again in our July webinar series, which is intended to unpack the 3 amendment acts that the President assented to on the 25th of January 2022. So today our focus is going to be on the National Register for Sex Offenders. As you know that in 2018, women took to the streets and were marching against a number of issues. And one of the demands was the limited protection that the National Register for Sex Offenders is affording women and girls and boys in South Africa. So now there are a number of changes that have been introduced by the Criminal Law, Sexual Offences and Related Matters Amendment Act of 2021 in Chapter 6 that encapsulates the management of the National Register for Sex Offenders. So today, we're going to be learning as to how wide is the protection that is afforded by this register to ensure that then many of us as women and children in South Africa, we are protected. And secondly, the question of also the accessibility of the register is also very important. It's one of the issues that came through in 2018 to say that how can we as women access this register? For instance, I'll make an example. If you want to get married and you don't know whether this person is registered, how can you access that information so that you are protected by the law of the country from getting married to people who are registered in the National Register for Sex Offenders? And also, I think the other issue that is very critical is for us to know as to what happens to a person who is in the register, all right? So what are the restrictions that apply particularly to the rights of that person who has been registered? And for how long can a person as particulars remain in the register? So that's the information that we need to know today. And we have in our midst then the National Register for Sex Offenders, and we'll be unpacking it to us all these salient changes that has been introduced by the Amendment Act. And now I would like all of us as we are here to switch off our mics and also to switch off our cameras. These are the rules of engagement in this platform. And I would also like a request that if you have a question as she's going through with the presentation, drop your question on the chat and we'll be giving you an opportunity then to receive the response to that question. And I would also like then to say that at the end of the presentation, we'll also be giving an opportunity for the Viva Voce questions. So if you want just to express your question orally, we'll be giving you that opportunity. And now it's going to be over then to Miss Makila. Miss Makila has been the National Register for Sex Offenders since 2009 when it started to implement. This is the register that started to be implemented on the 30th of June 2009. So she has been there since its inception, and she's the person who also participated in the amendments for Chapter 6 that speaks then to the management of the National Register for Sex Offenders, and she's the one who's going to be taking through the presentation. So thank you. Over to you.
Thank you. Thank you, Advocate Kambula, for
the introduction, and thank you also for the participants online. Let me try sharing the screen. I'm not sure whether it's now visible. Okay. Good morning once again, colleagues. Like Advocate Kambula has said, when we started, today's presentation is going to be about the criminal law, sexual offences and related matters, Amendment Act with specific attention to the changes that have been brought about by the Amendment Act. But to give contextual issues around that, I think it is only fair when we can start by looking into what is it, or how did the Act look like before the amendments? What is the National Register for Sex Offenders? And then what are those changes, from where to where we are currently, so that you can have a sense of actually what is it that has been changed. As the introduction, we are all aware that the preamble of the Criminal Law, Sexual Offences and Related Matters Amendment Act 32 of 2007, which is the principal act, when it was initially enacted, just like what Advocate Kambula has said when she started, that the implementation of this particular legislation, although it is a 2007 legislation, its implementation started on the 30th of June, 2009. And the primary objective was aimed at protecting the rights of children and persons who are mentally disabled. At the time, the Act used to refer to persons with mental disabilities as people who are mentally disabled, but we'll come and then outline that in the subsequent slides when we get further down. So it further states that sexual offenses are primarily a social phenomenon which is reflective of deep-seated systemic dysfunctionality in our society, and that legal mechanisms to address the social phenomenon are limited and are reactive in nature, but nonetheless necessary. You would note that when they are saying that they are reactive in nature, when you pay specific attention to the National Register for Sex Offenders, it is not at the initial stages of the implementation or at the initial stages of the criminal justice system. We are reactive in nature because we take into account a conviction that has been made and a conviction that the court has, or a sentence that the court has effected. That is only then when the National Register for Sex Offenders becomes effective, in that once a court makes an order, then we record such a conviction in the National Register for Sex Offenders, which is why they say, even though it is reactive, but it is nonetheless necessary. Therefore, when we look into the enactment of the 2007 Act, the Principal Act, we see the demonstration of the intentionality of the legislature, wherein the legislature or the lawmaker is specific in the protection of children and persons with mental disabilities. That is why the National Register for Sex Offenders was created in the first instance. So on the other hand, when you look into Section 2G of the Act, wherein it outlines the objects of the Act, it says the objects of the Act are to afford complainants of sexual offenses the maximum and least traumatizing protection that the law can provide, And it also introduces the measures which seek to enable the relevant organs of state to give full effect to the provisions of the Act. When we're talking about those maximum and least traumatizing protection that the law can afford, you would have seen the department moving towards the area of creating sexual offences courts, wherein it will enable the sexual offences victims to testify in a dignified manner and to create a conducive space where this can actually happen. And then it also created or introduced measures which seek to enable the relevant organs of state, those departments that are in the criminal justice system, to give full effect of the provisions of the Act and to combat and ultimately to eradicate the relatively high incidences of sexual offences committed in the Republic, by obviously establishing the National Register for Sex Offenders. So in this slide, this is why in section 42, it creates an obligation on the Minister of Justice and Correctional Services to establish and maintain the National Register for Sex Offenders. So we are well aware that the minister himself cannot administer or administrate or deal with the administrative part of the register. So which is why it then articulates that he must designate a fit and proper person with due regard to his experience, consciousness, I'm sorry, I'm not able to pronounce this word, and integrity as the registrar of the NRSO. So it further provides that the registrar must exercise and perform his or her powers, duties, and function, which are subject to the provisions of Chapter 6 of the Act and of the regulation. So the very purpose of the Act, amongst other reasons, is stated as being to enact comprehensive provisions dealing with the creation of certain new, expanded or amended sexual offences against children and persons with mental disease. So with the aim to address the particular vulnerability of children or persons with mental disability. So when the National Register for Sex Offenders was initially created, it was set out to protect children and persons who are mentally disabled against convicted sex offenders. Because at the time, this is when they were abused the most. And as you may very well be aware, a child or a person who has mental disability does not or cannot give any appreciation of any, sexual offense being committed against them. So they wouldn't come and say whether or not I appreciate what you have done to me, neither can they consent to anyone who actually wants to do this against them. So in creating the National Register for Sex Offenders, the aim was to address that particular vulnerability of children and persons with mental disability in respect of the sexual abuse or exploitation that was perpetuated against them. So the function will then include the function of the register, will then outline that it aims to prevent repeat offending when we include the details of persons who are found guilty of committing a sexual offense against them. So this is done in terms of a particular section, which is section 50 of the Act, wherein when we established the National Register for Sex Offenders, we were required to get the details of convicted sex offenders who were convicted in the past before the Act came into operation. And then we also had to start now implementing by collecting the details of all sex offenders that have been convicted from 2009 henceforth. So another function, again, it prevents that persons who are previously convicted of sexual offenses against children and persons with mental disabilities, they cannot be allowed to work with or be placed in circumstances where he or she will have access to them. And this we do by issuing the certificates in respect of particulars. Section 41, for instance, if a person now is convicted and then you find them working in a space where children are congregate or persons with mental disabilities, they will be found guilty of contravening the provisions of Section 41 when you find them holding any position which places them in any position of authority or are employed or they supervise or exercise care of a child or a person with mental disability. So it further prohibits that when anyone applies to get a license to manage or operate any entity, business, concern, or trade in relation to supervision over a care of a child or a person with mental disability, it also prohibits that we give out licenses to a convicted offender or giving out a where a person applies to become a foster parent, wherein a court will then approve that that person fosters a child, apply for kinship caregiving, temporary safe caregiving in that space, or becomes an adoptive parent. If you've got a previous conviction or a current sexual offences conviction, you cannot be allowed to even adopt or foster a child of your relative or a sister that has already passed on or a brother. So how the National Register for Sex Offenders was then established is because the establishment itself was created or was done in terms of Chapter 6. This is the Chapter 6 that Advocate Kambula spoke about when she opened. The creation of the establishment of the National Register for Sex Offenders is provided for in terms of Chapter 6 of the Principal Act. And it aims to regulate, obviously, what the management and administration of the National Register for Sex Offenders. In short, it requires that particulars of persons who have been convicted of any sexual offense against these two categories of persons must be recorded in the National Register for Sex Offenders. It also prohibits that these persons must work or be placed in circumstances where they have access towards them. So relevant employers are required to vet existing employees and potential employees against the National Register for Sex Offenders in order to determine whether they are suitable to work with them or not. Now, we will look into the composition of Chapter 6, what Chapter 6 in the previous dispensation or in the current dispensation is actually composed of. In Section 40, that's where it outlines the definition. Section 41, which is the one that we've spoken to about now, it's a prohibition of certain types of employment by certain persons who have committed previous sexual offenses. And Section 42 is the one that we also spoke about. It's about the establishment, how the establishment of the National Register for Sex Offenders then pans out. How is the person who is designated as the registrar will then be designated. And then Section 43, it talks about the objects, and 44 all it outlines the category of persons who can apply for a certificate in respect of particulars. Section 45, these are the obligations that are placed on employers who have appointed employees who work with children, just like our Department of Education or the Department of Health, which often access children in any way, manner, or form, whether as patients, whether as school children and stuff like that. So Section 46, it deals about the obligations of employees. For example, this is where if you know that you've got a previous conviction of a sexual offense, you are obligated to disclose to your employer to say, note that I've got a previous sexual offenses conviction, even though I do know that the act was not operational at the time when I was employed. But now that it is operational, please know that I have a previous sexual offenses conviction, to which if you do, then it says on the obligations of the employer must either remove you from where you access the children to a place where you will not access them. Or if they cannot remove you and to place you elsewhere, which means then they have to actually let go, because since the coming into effect of the 2007 Act, no one who has a previous conviction was allowed to access children and persons with mental disabilities. Section 47 is the one that looks into obligations in respect of license application, where one has to open an entity that takes care of children, whether in a workspace or like crèches or those aftercare facilities. And then section 48, this is where it talks about obligation in respect of persons that apply for foster care, kinship caregiving, safe caregiving, adoption of children, and curatorship of persons with mental disabilities. Section 49, it has the contents in terms of what can be recorded in the National Register for Sex Offenders. And section 50, then it outlines who can be included in the National Register for Sex Offenders. This is a person who has a previous or a current conviction of a sexual offense, or who a court then convicts of committing a sexual offense against the child or anyone who's mentally disabled. Then it requires that the court must make an order. And when the court makes an order, then that order must actually be recorded in the National Register for Sex Offenders. Section 51 is the one that looked into the particulars or the removal of particulars, the circumstances under which a person's particulars can be removed from the register. Section 42 is about confidentiality and disclosure of information. As you may recall, when we were dealing with the amendments towards the Act, one of the factors that came prominently was for the disclosure of information from the register, because people wanted to feel safe, people wanted to feel that the register is actually indeed safeguarding their interest, and whether or not the people that they live around, whether or not they are not sex predators. But in looking into whether or not the information in the register can be disclosed to the entire population and society to view, this was something that was tested against the Constitution. As you may very well be aware that whenever we pass any legislation, it has to pass the constitutional muster, which means it has to be compliant with the Constitution and the Bill of Rights. But when we looked into the disclosure of information in that space, we were found wanting that even if when we can be challenged in the court of law, we will not be successful on the basis that it violates the freedom or the right to someone's privacy. So in that space, the register could not be made public. However, when we move into what are the new amendments that are brought up, we will then deal with this issue at length. Section 53 is the one that looks into the regulations that are pertaining to the register. And section 54, it speaks about the obligation to report the commission of a sexual offense against children or persons with mental disabilities. Now, we are zooming into the criminal law, sexual offenses and related matters, Amendment Act, Amendment Act. This is the amendment that was assented to by the President in January this year. So the very amendment still outlines sexual exploitation and sexual grooming of children and persons with mental disabilities. It provides, or it still provides, that perpetrators now of any sexual offense against vulnerable persons must be recorded in the National Register for Sex Offenders. You will note that the narrative now has changed. We're no longer focusing on any sexual offense that has been committed against a child or a person with mental disability. Now it says, it provides that perpetrators of any sexual offense against who now? Now the attention has been moved to only children and persons with mental disabilities, but it now includes a new phenomenon, which is the vulnerable person, to say it will be recorded in the National Register for Sex Offenders. We will then outline who then this vulnerable person is. And now, in this manner, this is how Parliament responded to calls to tighten up the management of the National Register for Sex Offenders. So those who have been convicted of committing now any sexual offense against any person, including a vulnerable person, or has a previous conviction in this respect, or you have been sentenced to less than 18 months, at least you can have your name removed after 20 years has lapsed. Now, the objectives of the Amendment Act we're looking into now, it aims to extend the ambit of the offense of incest as to provide additional protection to children. It has also introduced a new offense of sexual intimidation to protect persons from threats of imminent sexual harm. If a person threatens you, you know that some people use the language loosely, and a person will be saying that I was joking around in terms of this is what I will do to you. But if then you perceive that that is a threat of an imminent sexual harm, then you are protected. You can take that and report it to the police, and then they will afford you protection. So many of the amendments that have been effected in the criminal law or in the Principal Act, they are technical in nature, meaning that it is not that substantive, except that there are other like sexual offenses that have been introduced to add into the package that we have. If I can go back to the composition of the Principal Act, we find in Chapter 2 where all sexual offenses are defined. However, when we get into Chapter 3 and Chapter 4, you only have sexual offenses that can be committed against the child and sexual offenses that can be committed against a person who is mentally disabled or a person with mental disabilities. So when I say the changes thereof are technical, which means wherever a person who is mentally disabled appears, it has now been substituted or replaced with the phrase person or persons with mental disabilities. We have been advised that there is no person that is regarded as a person who's mentally disabled, even though in the previous dispensation it appeared that we were referring to a person with mental disabilities as a person who is mentally disabled. So wherever a person with mental disabilities, which means in the entire Chapter 4, in the entire Chapter 2, where a person with who is mentally disabled is then substituted with persons with mental disabilities. Now, when we look to 6.4, we say it further regulates the inclusion of particulars of persons in the National Register for Sex Offenders. When I was presenting on the Principal Act, you would have noted that we said the only sex offenders that could have earned their inclusion into the National Register for Sex Offenders were those that were convicted of committing sexual offenses against children and persons with mental disabilities. Now, if we say the new amendment further regulates the inclusion, you would have noted with specific emphasis when I said now it regulates the inclusion of any person who is found guilty of committing any sexual offense against any person, including vulnerable persons. So, which means now, the person that will earn an inclusion into the National Register for Sex Offenders, we're no longer looking into those categories that they've offended. We're now looking into any person that has committed any sexual offense against any person. Then your name will be included in the National Register for Sex Offenders. So the scope of the National Register for Sex Offenders has been extended in that manner. It says it extends now the list of persons who are protected in terms of Chapter 6. Initially, Chapter 6 used to protect children and persons with mental disabilities. Now, the scope has been extended also by what? Vulnerable person. Now we are defining who a vulnerable person is. A vulnerable person still is a child and a person who is mentally, or a person with mental disability, any female person under the age of 25 years who it qualifies, it's not everybody under the age of 25, but it qualifies then who this 25-year-old is any female who receives tuition at a higher education college, higher education institution or university college as defined in Section 1 of the Higher Education Act. So these are all individuals that are currently attending university or school there or who are studying. So it's anyone who receives vocational training at any training institute other than the institutions that are referred to above as part of their employment. This is, your interns who are doing practicals, or those teachers who are doing practicals at any school. That person must be living now where? In a building or structure or facility used primarily as a residence for any persons referred to above. So those ones who are staying in dormitories, in hostels, in varsity residence, and or a person who is being cared for or sheltered in a facility that provides services to victims of crime. On D, we also include any person with a physical, intellectual, or sensory disability. You would note that in addition to anyone who has mental disabilities, we have now taken note of physical disability, intellectual, or sensory disability, and who receives community-based care and support services other than from a family member, or who lives in a building, structure, or facility used primarily as a residence for, or is cared for in a facility providing 24-hour care to persons with physical, intellectual, or sensory disability. And additional to that, we have anyone who is 60 years of age. You will note that from 25, nothing is said until when we come to 60 years of age or older, and who receives a community-based care and support services other than from a family member, who lives in a building or a structure or facility used primarily as a residence, or is cared for in a facility which is providing 24-hour care to such persons. The objectives are still extended. It also extends now the list of persons who are entitled to submit applications to the register. In the previous dispensation, the people who were allowed to submit submit an application for a certificate, we're looking into 6 categories of persons. We're looking into someone who was applying in his own right. we were looking into an employer, we were looking into an employee, a licensing authority, a relevant authority can be the courts, or it can be, the government departments that actually needs to ascertain by way of application whether or not the details of an employee are there. It can be an employee in his own right, or someone who already knows that their details are listed in the register. Then they were the only category of persons that were allowed to submit an application. By now, it says it extends now the list of persons who are entitled to submit applications to the registrar. Now, the scope of those people that can submit an application has also been extended to include who? Any other person that seeks to view by way of application whether or not the details of anyone exist in the National Register for Sex Offenders. Even though when we were deliberating about the constitutionality of submitting an application, we said we will allow that anyone now submits an application to the registrar to view whether or not the details of any other person exist. But we were not going to make that an open-ended application wherein you can simply click a button from your internet and then type in the details of Ntomzoto, and then you see that Ntomzoto is there. We need to do this in a controlled fashion wherein you submit an application. However, when you submit that application to view whether or not the details of anyone exist in the National Register for Sex Offenders, the registrar must be satisfied that the application that you're submitting is not frivolous or vexatious, or that that particular application that you're submitting is in the interest of a vulnerable person. If it's not in the interest of the vulnerable person, that is the basis upon which the registrar or anyone that is delegated the function to perform on behalf of the registrar can say your application to check whether or not the details of X are listed in the register. This is the basis upon which such an application for a certificate can be removed. Now, when it says it further regulates the removal of particulars of persons from the register, initially in the Principal Act, we only had 3 timeframes that were articulated. For example, if you have been convicted to a sexual offense against a person or against a child or someone who has mental disabilities, for any other lesser form of a sentence, your name was going to stay in the National Register for Sex Offenders for 5 years, before which you can be allowed to apply for removal. That 5 years has been doubled to 10 years. And if you have been sentenced to a period, whether it's periodical sentence, whether it's a fine, whether it's a suspended sentence, whether it's correctional supervision, it wouldn't matter. But if you have been convicted to a sentence of not more than, or of between 6 and 12 months, your name was going to stay in the National Register for Sex Offenders for 10 years, upon which, for 7 years, I beg your pardon, for 7 years, upon which you could then qualify to have your name removed after 7 years has lapsed. But now the 7 years has been doubled to 14 years, which means you can apply to have your details removed from the register after 14 years has lapsed. Now, at the end is the one which I opened with. If your sentence is up to 18 months, but not exceeding 18 months, you can apply, or you could apply to have your details removed from the register after 10 years has lapsed. But now the period has been doubled to 20 years. You can only apply to have your details removed from the register after 20 years has lapsed. But anyone who has a conviction of 18 or more, or 2 or more convictions, that person's details may not be removed from the National Register for Sex Offenders. So essentially, it means they will not be able to work with anyone who is vulnerable, or to work at a place where the vulnerable persons are congregate. So in 6.8, it says it further regulates the reporting duty of persons who are aware that a sexual offense have been committed against the person. Initially, in the previous or in the Principal Act, we had Section 54 being outlined. However, it did not outline what will then happen if you are aware that a sexual offense is committed against a child or any vulnerable person, what's going to happen to you if you don't report and you are aware that they are being sexually violated. Now we have placed, those penalties to say failure to report. You can be charged or you can be fined. Over and above, if the court finds you guilty, you can be fined and be sentenced to not more than 3 years in prison if you fail to report. Because essential or at the center of this Amendment Act, you will also notice with the Domestic Violence Act, it discourages the culture of bystanderism, where you are aware that a sexual offense is being committed, but you are not reporting that accordingly. Where you are aware that is committed, even if you've got a reasonable suspicion that a sexual offense is being committed against the person who's vulnerable, you have to report that to the police, and the police must start investigating. So this one we've already dealt with, where I have outlined that in the Principal Act, who was allowed to apply for a prescribed certificate which states whether or not the particulars of a person mentioned are recorded in the National Register for Sex Offenders or not. So these are all the categories that I've just outlined to say who can or who was allowed to apply in that space. So the one that is being brought about in the amendment is where it says any person wants to determine whether the particulars of any person have been included in the register or not may apply. However, there are concessions where if that particular person, the registrar or anyone who's discharging those functions feels that this is being submitted maliciously, vexatiously, those will be found to be the grounds upon which such an application will not be proceeded with. So that's basically that I have about or around the National Register for Sex Offenders, and then what actually are the amendments have brought about in a brief format. And I would like to thank you for your audience. And then this has now brought us to the end of the presentation, and thank you so much for your attention. Over to you, Advocate Kambula.
Thank you so much. Thank you so much, Ms. Makila, for the information that we have received. Quite interesting. So many changes that have been introduced. And now I'm opening the floor for questions. If you have a question, please, you can ask your question by raising your hand, or also by dropping your question on the chat. Looking for the questions now that are on the chat. Let me just check. Any questions from the floor? Anyone who's got a question? We have received so much. It's quite very interesting, the information that we have received, particularly on the issues of the access to the register. I think many of us would like to know more and to have this information, simplified further. Any questions? All right. So what it means is that we had such an excellent facilitator, explained a lot of stuff. All right. So we have one comment that is coming from Aisha. It says that thank you for the powerful presentation. There are absolutely no questions. So then this is going to bring us to the end of the session. Therefore, if we do not have questions, so we thank then our there's Daphne. Daphne wants to know what's the difference between the Child Protection Register and the Sexual Offences Register, meaning that the National Register for Sex Offenders. I think that's very important, Daphne, because we really need to know whether are these two registers a duplication, are they providing the same services? What's the difference if they are not? And whether it is because right now, as you know, that we have amended the determination for persons competent to be appointed as intermediaries. And one of the requirements is that they must be vetted against the National Register for Sex Offenders. And so then do they need then to be also vetted against the Child Protection Register? What protection is, what's the difference between the two registers? I think that's a very important question. All right, so that is the first. And then wants to know, is also asked, is there any duplication between these two registers? And mind you, there's also a third register that is for the abuse of persons, of older persons register. So what's the difference between these three registers? We would want to know. Those are the questions. Let me just check if I cannot give you another question. Mpalo says that I would like to have clarity around scholar drivers who will be taking my kids to school, if I can be allowed to get a clearance from the register. All right, that's very, very important. And also, you know, we also need to know from the National Registrar here whether even your nanny at home, whether your nanny need to be cleared, all right, because you're gonna be living here with your children, all right. So, and that's a direct exposure to children. So, do we need then to have them vetted against the NRSO before they can take up that responsibility? That's very, very, very important. And it's not only the driver who's gonna be taking your children to school, but what about the taxi drivers? All right, the taxi drivers, because they are also having the direct exposure to our children, and they are providing a service there of taking, you know, people from point A to point B. And during the course of that work, does it mean that then, because they have a direct exposure to children, have a direct exposure to the expanded scope of people who need to be protected? Because right now, it also includes women below the age of 25 and so on. So will they be vetted? So that's another question. And Dombi, that's going to be coming to you. And we also have then Elmari. He says that good day, well presentation. The question, if a case against a mental child of rape abuse was not prosecuted, can we request reopening of the case? All right. So Elmari is asking that question. Can that case then be reopened? I hope that it's a case that was withdrawn, all right? Because if it was, say that it's a case, it was not prosecuted. So if it was not prosecuted, then I suppose it was the charge was withdrawn. Can that charge be reinstated? That's the question, all right? So I'm going to give you just the last question that is coming from Dululu, all right? It says that I have some questions, but I'm not sure if I'm able to use my mic to talk. My mic, I'm the only one with this, wants to know if she's the only one who has this challenge. So Dululu, we're gonna be asking that, the administrators to check the mics, whether you'll be able, because we also need to get the Viva Voce questions, all right, so that you are able then to express yourself, the way that you would wish to. Now, let's hand over then to the National Registrar, all right, Registrar, to respond to the questions.
Thank you for those challenging questions. For a minute there, I was asking myself whether or not am I going to answer. But the first one from Daphne around whether or not the National Register for Sex Offenders and the National Child Protection Register is not a duplication. That's a very powerful question. For some reason, I'm not going to answer in a no or a yes, but in my answer, you will then extrapolate, the differences between the two and why is government still proceeding, even though it looks like there's a duplication in those two registers. The National Child Protection Register is the one that records or keeps record of anyone who is found guilty, number one, of committing any form of abuse, which is inclusive of sexual abuse in the National Child Protection Register. So the determination or the finding whether or not this person can be placed in the National Child Protection Register is not only vested in the court of law, but a tribunal can also sit, a disciplinary committee can also sit and make a determination of unsuitability of a child in that respect. But it's neglect, abuse, sexual abuse, everything, but all forms of abuse. But with the National Register for Sex Offenders, you will find that it was only established to keep a record of anyone that is found guilty of committing a sexual offense against a child or anyone who with a mental disability. That has been the case until such time when we could get, the amendment in place. However, we only look into all cases that have gone through a court of law and where an order of a conviction convicting that particular person of a sexual offense has been issued out. One other aspect into this particular registers, it also goes on to the very mandate of each department. Department of Social Development is actually placed in a space where it can actually make determinations, come with interventions where a child is neglected, where a child is abused, whether physical, whether it's sexual, and so on and so forth. But the Department of Justice, if you could have noted my presentation at the start, we said even if this is reactive, but it is a reactive mechanism which is necessary that we do that. We come at the back end of the criminal justice system after everything else has been investigated, prosecuted, determined by the court. This is where we come in as a repository where we get each and every conviction, but we focus only on a sexual offense conviction, and that has been made against someone who has done that against a vulnerable person now, no longer is a child or anyone with mental disability. So this is where the structural differences are in terms of the NCPR and the NRSO. However, again, The duplication part that we've actually realized, it is when you apply for a certificate in respect of particulars on the NCPR as well as on the NRSO. Currently, you have to submit 2 applications to 2 different departments that may come back, confirming one and the same thing, whether or not that person does not have this and that, including a sexual offense. We are looking into having a structure wherein you can be able to submit an application through one conduit and get a result wherein you are viewing through all forms or the registers that will be in place, which will come confirming whether it's not NRSO, it's not NCPR, it's not older persons. We are still working on that to formulate that particular transversal hub through IJS, wherein we are going to limit, all the pockets of entry into applying for a certificate. One other issue that was asked by Mr. Mpalo is whether or not can you not apply. Now, the act has been amended to allow anyone that wants to view whether the details of any person exist. This is inclusive, especially when you have hired a scholar, Malome David, to ferry your children to and from school. The taxi drivers, because you know that it's not only the school children that use that scholar transport or use a taxi. You will have the vulnerable persons, you will have the varsity students, you will have the older persons that would require to use the services of a taxi driver. We currently have started now the process of vetting, or we are going to start once the commencement date is announced, vetting the teachers accordingly. Then we would move gradually to the Department of Transport, the scholar transport space, and all those. And one other thing also, if you have appointed a nanny at your house to look, or a tutor, more especially nannies, because in the previous times we had thought that sexual offenses were only structured, or it was only male persons that were capable of committing a sexual offense against the child. Unfortunately, you also have to look into the nannies that you have in your space, because we have seen a trend in KZN in Mpumalanga, where you find female nannies that are prying now on male children or on boys, wherein they are sexually grooming them, because sexual offense is no longer that physical where you look into the rape as in that rough, act. We've got sexual grooming, we've got pornography, we've got sexual assault, which takes all forms of, non-violent, but psychologically it is very damaging. And you find that these are the crimes where nannies have failed prominently in doing that. So even when you've got a gardener, you've got a nanny, you've got anyone that comes into contact with your children, you need to ascertain by way of application whether or not that particular person does not exist in the National Register for Sex Offenders. You must be sure that the person that accesses your children on a daily basis or whenever, their details are not appearing in the National Register for Sex Offenders. So on the issue of reopening a case that never went through, yes, you need to do that. Remember that a sexual offense never expires. So if something that was done that was not done correctly, maybe lack of evidence or anything else that would have led to a case being withdrawn, it is your right to go and reopen it and see it, or see to it that it is reopened, and then so that the perpetrators can be brought to book. Which is why I said, even if you've got a reasonable suspicion that a sexual offense is committed against any vulnerable person, you must report that accordingly. I think that I've dealt with all the questions. Let me mute.
Thank you, Ms. Makila. Now, there's just another question. Is coming from Mr. Mpalo is asking, what about people who committed bestiality? Will they be registered? Okay, so it goes to, is it a criminal offense? Because everyone who has to be registered has to commit and be convicted of a criminal offense. And then we also have another question that is coming from Elmari, is asking, not withdrawn, or she says that not withdrawn. DPP said that they are not going to proceed with the prosecution. So what it means is a nolle prosecute decision that she's talking about. Why I don't know. So why I don't know, that is the reason for the nolle prosecute decision. And I think this case needs, this is what she continues to say, and I think this case needs attention, as it's a disabled child. He was shackled with chains, raped, abused, neglected. Father and the mother was just give bail, or was okay. They were given bail for 5,000 rand each, and the case reported in 2019, and in January I was told that the director of public prosecutions is not proceeding with the case. Justice did not prevail for this case, and I won't leave this matter. This is what she is saying, all right? So it's a nolle prosecute decision, and wants to know as to whether this case can be reinstated involving a child with a disability. And Dululu is coming through to say that please let the registration to again talk on this issue of 18 months or less versus 20 or 14 years are needed to be clarified. So I think here she's asking about the periods, that the particulars of the registered sex offenders can remain in the register. So please explain the issue of 18 months, what is it for, and 20 and end, all right? And then we also have here, all right, and also point the failure to report, all right, or what would be, the consequences of the failure to report, and the sentence for such. So I would like to believe that it is the failure on the person, when you get an employment and you don't disclose, and that your name is in the register. What will be the consequences, the legal consequences for the failure to report such, all right? And if you can also touch as well, on the part of the employer as well, because this act places a legal obligation on the employer to have the particulars, to vet the employees who are exposed to the category of persons that are protected by the register. So what are the legal consequences on the employer who has failed then to obey the obligation, all right? And because the employer, when you talk about the employer, all right, we need to also understand that the employer includes the government employers as well, all right? So this question is coming from Dululu of DBE, Department of Basic Education. And as you know, that the Department of Basic Education has got all these educators, so they are exposed then to children. So what if then the Director General of Basic Education fails to have all the educators vetted what will be the legal consequences, because it's an employer. And is he not committing a crime? All right. Will it be proper then for somebody to go to the police and lay a criminal charge against the director of basic education? All right. So, because he's an employer. All right. So as an employer, then he needs to be charged, but then we will get the response from the registrar. Then El-Marie is coming again to say that thank you. The case will be reopened. That's the response from. Now we have got Estella. He says that, good morning. I just wanted to know, is it possible that one can get the minutes of this meeting? I joined towards the end to a complaint I had to attend to. Okay, it's something that she needed to. So I would like just to say, Esther, that just drop your email particulars here. All right. So because if we have your email, if we would like to get, because this is a series, it's a webinar series, so meaning that we still have more to come. So drop your email address and we will get you into the mailing list for the webinar series. All right. And it's now because of the public demand. So we're going to move it into the month of August. We're coming with brilliant topics that will be dealing with different topical areas of the salient changes introduced by the 3 Amendment Acts, because there's quite massive changes, particularly with the Domestic Violence Amendment Act, and also with this one that we're talking about right now today, the Criminal Law and Sexual Offences and Related Matters Amendment Act. So we're going to be coming in with different approaches and looking into how then we could simplify, these amendments. So now just drop in your email address and you'll get into the mailing list. And you will also be getting the invites directly, all right, to other webinars. And also then the third thing, if you give us your email address, is that you'll be getting all the presentations. All the presentations, you'll be getting them, and so that you can use them, particularly if you are the facilitator. So you'll be able then to have your own training workshop and use the products that you'll be getting from here. Now, over to you, Ms. Michaela, to respond to the questions.
Thank you, colleagues, for the most interesting questions. With El-Marie, I think you have been answered. Definitely, you must reopen that case, because then it's a miscarriage of justice if we are aware that this has happened. And I would advise that you escalate, because the reasons for the nolle prosequi, I don't know what could have been or what could have caused that, especially when we're looking into the best interest of a child, more so that child has a disability of some sort. So I would advise that you go and you reopen that, and then let's follow that up to ensure that the perpetrators are actually brought to book, because even social development must be roped in there, because there is neglect, there is abuse, physical abuse of a child as well, that when you were relating the story, I could sense there. Coming to Mr. Mpalo, you would note that bestiality, although it's a sexual offense, is not a sexual offense against a person. So having said that, when you are found guilty of committing bestiality, your name will not be included in the National Register for Sex Offenders, but in terms of the amendment, because it is a sexual offense, it will be included. But in the previous dispensation, because it was not a sexual offense against the person, it wouldn't have been included. Now, the only inclusion that it ends is because it is a sexual offense. It's any sexual offense, but because it is not committed against a person, you will not have it feature, even if that person is convicted and sentenced accordingly. It's not a sexual offense against a person, but against an animal. Dululu, the issue around I will start with talking to the issue of the time frames that are actually allocated. If you have been convicted to a sexual offense and sentenced to anything which is less than 6 months, we call it that it is a lesser, not a lesser offense, but we say it's a lesser sentence. When you have been given a lesser sentence, your name will be included in the register, and then it will remain for, initially it used to get in there for 5 years, but now it will remain in the register for 10 years before you can actually qualify to have your details removed. And then we have a period that goes from 6 months to 12 months, thereabout. That person who gets such a sentence will stay in the register for 14 years before they can actually qualify to have their details removed. We're not talking about expungement, we're talking only about removal from the National Register for Sex Offenders, which can serve as a precursor for you to go and apply for an expungement. That is only if you do qualify to have your record expunged. And for someone who has been convicted to 18 months and lesser, that means 18 months up until before 12 months thereabout, your details will remain in the register for 20 years, before which you can qualify to have your details removed, and before you can actually start thinking about having to expunge your record, only if you qualify to have your details expunged. So we will come to the obligations of the employers, wherein you have asked the question, who is an employer? Whether or not the Director General of your department, if you are not vetting the teachers as you should, whether or not it is, what happens against failure for someone to, is there any legal obligation on their part? So I'm going to talk about the employer, the obligations of an employer in respect of employees, and the obligations of employees in respect of employers. The Act says at the commencement of this chapter, which means in 2009 already, any employee from the date of the establishment of the register was supposed to, in a prescribed manner, apply to the registrar for a prescribed certificate which states whether or not their particulars are recorded in the register. This was obviously to protect the children that these people were coming across, or any person who was any person with mental disabilities, who this people will then access them in an employment space, whether or not they're exercising supervisory functions over them. And then it was also looking into anyone who was intending to employ an employee, like an employer was intending to have those potential employees, that they were actually expected to apply to the registrar to check whether or not the details are there. And it also says an employer who during the course of the employment relationship, during jury, you ascertain that there are other employees that have been recorded in the National Register for Sex Offenders. So this is irrespective of whether such an offense was committed during the course of their employment. They must immediately, if you do ascertain that that person is there, you must do what? Terminate the employment of such employee. You said whether or not there was a legal obligation. Yes, there is a legal obligation to ensure that anyone that has a previous conviction, has a current conviction, must not work with children in your space, in the education space. They must not work with children. They must not come across. Even in the adoption space, you will not be allowed to adopt. So, which means if you must also terminate the employment of the employee who fails to disclose the previous conviction, that I've been previously convicted of a sexual offense in 1999. If they have failed to disclose that, you must terminate their employment relationship. So the Act further says the employer who fails to comply with any provision is guilty of an offense and liable to a conviction. Liable on conviction. Let's say if they convict, if the court finds you guilty, your DG is liable to a fine or imprisonment for a period not exceeding 7 years, or to both a fine and such imprisonment. It's a criminal offense, actually. If so, the same goes to an employee. If an employee does not disclose, his employment must be terminated. If he fails to disclose again as an offense, there is such an offense again that if they fail to comply, they are guilty of an offense and liable on conviction to a fine of imprisonment, which is not exceeding 7 years, or to both a fine and such imprisonment. So I'm not sure if I have dealt with all the questions that were posed.
Thank you, Ms. Makila. Explained so well all the questions. Let me just check now if we do have more questions. We've got a Brigadier Bucas. It says, good morning. Thank you for this very informative session. Please add me to the webinar. Wants to be added, we'll certainly do that. All right. Now, do I have oral questions? Is there anyone who would like to ask a question? The Viva Voce question? Anyone? All right, then in the absence of that, then I think this is going to be bringing us to the end of the session. So we, okay, I'm going to just be checking on this side. All right, so Dululu, I have just been informed that we can take your question, your Viva Voce question. If you are still on the platform, they've opened your mic.
I am still on the platform, Sis Grace, but I think my questions have been answered. The ones that I put on the, yeah.
Okay, all right. So you're going to ensure that your DG is not arrested, eh?
Of course, otherwise,
exactly. We're going to let a criminal offense go to the police and open a docket. Okay, all right. I'm recognizing your hand, Elmari.
Good morning. Can you hear me?
Yes, we can. Loud and
Morning.
clear.
Thank you. I just want to find out, just for information or just for interesting sake, Section 54, has there ever been any conviction to any person that had knowledge of this section and they have not came forward and reported the matter, knowingly that a child or a person has been raped or abused, and they just get quiet because they fear to go to court and held liable, accountable for knowing and not saying anything? Have there ever been a case where somebody has been charged with that? Because if I tell somebody, you know what, you knew about this matter and you never reported, according to Section 54, then they say, nothing will happen. So anyway, you can report the matter, nothing comes from the matter. So if we can have that section, being very important, marked as one of the most important sections, I think people will then, decide, rather let me speak up than getting a conviction myself.
Mhm. 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 Yes, you know what, Elmarie, we are going so strongly right now, to ensure accountability of all adults living in South Africa, because we have Article 1 and Article 2 of the Presidential Summit Declaration that actually places a responsibility, just praise, because it's a summit declaration, so it places a responsibility on all persons living in South Africa and to take to end, it's a responsibility to end gender-based violence and femicide. All right, so now taking that article and building it in our pieces of legislation, we have translated it from a responsibility into a legal obligation. But now, to respond to your question, is to say that that will need, it's something that we need to check from the NPA. But right now we are on a drive, a public awareness drive, to ensure that then bystanderism in sex crimes perpetrated against children and persons with mental disabilities, and also the older persons, and that includes, and also in matters of Domestic Violence Amendment Act. I'm not sure whether you are aware that even in the Domestic Violence Amendment Act, now it carries a provision that places then that legal obligation on any adult, irrespective of whether you are a national or a non-national. But for the fact that you are living in South Africa, then it places a legal obligation on you to report any act or any suspicion of a commission of an act or omission of an act of it's a commission of an act of domestic violence, perpetrated against children, persons with disabilities. For the domestic violence, it does not clarify, it does not categorize the type of disability, but it says that all persons with disabilities, and also the and also the older persons. So meaning that now we are moving towards eliminating bystanderism in domestic violence matters and also in sexual offenses matters. So something that we need to, we are committed in doing that, to ensure that then this message gets out there, people are aware. And I would also like to say to you, Elmarie, that yesterday we had a webinar that was focusing on accountability, all right? Because as functionaries now, we need to take that responsibility of raising that awareness to everyone, to say that now you'll be committing a crime if there is a 10-year-old child, a neighbor, who is pregnant, and you are quiet, because why a 10-year-old child is pregnant? So
Yeah.
it means that there has been a sexual crime perpetrated against that child. So as a neighbor, you have a legal obligation, not legal responsibility. There's a difference, because if it's a legal obligation, then it can carry the sanction, non-compliance thereof. So now you have a legal obligation to go and report. And also the act then protects you as a whistleblower, all right? In the terms of the Domestic Violence Amendment Act, it says that no civil action must be instituted or criminal action instituted against the whistleblower, all right? If that disclosure was made without any malice, all right? So you can go and report your neighbor and say that there's a child there who is pregnant, and the police then must you'll be making that charge in terms of Section 54 of this particular act, all right? And the same applies then to the Domestic Violence Amendment Act. So it's something, I'm happy that we have raised this question, because it's something that we really, really need to know about. I think that also the National Registrar would agree with me. I don't know if there's anything that you would like to add, Ndombi.
Yeah, just on,
Yes, Elmarie, on the basis, I agree fully with what Advocate Kambula is saying. The previous act on Section 54, it only came to a point where it says if you're aware that a sexual offense is being committed against the child or someone with a mental disability, you've got to report to the police. So in terms of the amendment now, which is why we will not see anything on the table now, whether or not someone has been arrested, charged for not reporting. This is a new amendment that has come forth, which was amending Section 54 to say failure to report. This is what is going to happen. I simply just wanted to add there that we don't have anything as yet, but moving forward, this is the amendment that came forth in terms of Act number 13 of 2021 of the new amendment. Thank you.
Okay, we do have further questions, all right? There is one that is coming from Dululu. Wants to know the request for checking the name in the National Register for sex offenders. Does anyone apply, or meaning that does it allow any person to make that application, and what will be the process for such? So if Dululu wants to make an application, will she be allowed to, or are there any specific categories of people who can actually make this application? I think that's the question. And we also have a question from Estelle. Good morning. I just wanted to know if it is possible that one can get, okay, I think I read this one. Okay, all right. So that's the question. If you can just respond to that one. And we're also receiving then the comment that is coming from, which I think that we need to know. Lebu is saying here, Leu Motang from Free World Initiative. He says he's looking forward to the number of reporting and convictions going up. Me too. I'm waiting for that. And I also want to, yes, just to say one thing, that, you know, in South Africa, we have been, I think that was in 2018, starting from 2018, 2019, and even in 2017, we saw the skyrocketing figures of femicide, all right, in our country. But right now, the challenge that we are experiencing now is that the femicide cases have gone down, all right? Not to say that we already have a solution. No, we don't have, all right? We are still working towards bringing it down. And we also put together just recently the prevention strategy against femicide cases. But what we have seen now is the numbers of sex crimes going up. There's an upward trajectory in these cases. So, and something that is really, really concerning, all right, is that the age of the perpetrator of sex crimes now is getting younger day by day. We have a situation in South Africa of children who are perpetrating rape. They're not perpetrating any form. I'm not talking about any light form of a sex crime, all right? I'm talking about a rape, which is the most serious sexual offense because it is the one that includes the sexual penetration. So our children are perpetrating rape cases. And it's so sad that during the first year of COVID-19 pandemic, our courts experience a 22% increase of children who have perpetrated sex crimes, all right, rape in particular. And this did not change like in 2021, 2022, we still experience an increase of children who are perpetrating sex crimes, and the top offense perpetrated by children in the previous financial year, guess what? Rape. And in 2021, 2022, 50 children aged 14 to 17, all right, were convicted of murder. I'm not saying charged, convicted of murder. So we have a serious situation in South Africa. And this is something that as people who are in this sector to look into. So meaning that now our interventions should also be talking to children as well, all right? And would really one tell me as to why during the hard lockdowns, all right, levels that we had in 2020, 2021, where we experienced a 60% increase in child pregnancies, all right, teenage pregnancies. So what it means is that the poison is in the family. We need to rehabilitate our family values, all right? The poison is in the family because children were at home during that time. And so who is actually perpetrating sex crimes against our children? The poison is in the family. And secondly, where were the parents when 22% increase was experienced by our courts of children who perpetrated? I'm not saying that children who are the victims of sex crimes, but children who perpetrated rape. Where were the parents? Where was the visibility of parents during that time? So we are sitting with a time bomb in South Africa, and the future of South Africa is quite bleak, and we need to do something about this. All right. And I'm not sure if there was any question that was asked as to whether this register will permit children to be registered. So I would also like then the national registrar, to respond to that, because now we are having a situation of children who are raping women, raping their peers, all right, in South Africa. So what happened to those children who would go and steal sweets? We don't have them now. We have children who are perpetrating violent crimes, rape and murder being perpetrated by children. So that's the situation that we're having. So I would like then our facilitator to respond to these questions. Thank you.
Colleagues, I see. I see. Advocate Kamula is so charged up. She said she wanted a perpetrator to respond to questions. I will. On a question whether or not any person can approach the registrar to apply. Yes, in terms of the amendment, any person can apply to the registrar in a prescribed manner, which means you can submit an application form to determine whether the particulars of any person have been included in the register or not. However, it's not something that you can submit with malicious intent. There are factors to consider for anyone that will be performing that function, including the registrar herself or himself. It says the registrar in considering the application must be satisfied that the application is not frivolous or vexatious. The person who has submitted the application has the interest of the disclosure of the information, and the disclosure of information must be in the interest of the vulnerable person. So if the application that is submitted does not fit the bill, that is the basis upon which your application cannot even proceed further to the next stage. And you will see there are forms that are submitted, but the forms that are submitted, it's in a form of an affidavit, because now we are encroaching into someone else's private space. And in terms of the promotion of, excuse me, in terms of the Protection of Personal Information Act, to ensure that we don't violate that space again, it is an application that is going to be submitted in a form of an affidavit that you have obtained consent of another person that you are actually wanting us to give you the record for, because the National Register for Sex Offenders contains personal information of, whether we can say it's offenders or but it contains personal information of people. So when we taking out or when we issuing out information to the third party, you must have obtained consent from the third party so that you are not doing it clandestinely. So, which is why we have to look into those three factors. It's not vexatious, it's not frivolous, it's made in the interest of a vulnerable person, that we can start saying yay or nay. We don't just, issue it out, on a blanket. So there was another question again, whether or not children perpetrators can be included in the National Register for Sex Offenders. The answer, in short, is yes. However, when a child is involved, the court cannot necessarily issue an order automatically on conviction. There has to be three concessions that have to be taken into account. The prosecutor must either approach the court to request the court to issue an order, or the child himself or herself must address the court in terms of why his or her details cannot be included, can or cannot be included in the National Register for Sex Offenders. And the court must consider the report from the probation officer. You will see that child justice processes run concurrently in this instance. And it says at the end, if the court is satisfied that there are circumstances that are prevailing that necessitate for the court to make an order, the court must make that endorsement and place it in an order. It's not an automatic order that a court can make just in a case of an adult person who has violated a child or a vulnerable person. There, a court cannot ask you to address it in terms of whether or not why your details can be included. It's an automatic inclusion. But when a child is involved, the court must take that into account before it can actually make such an endorsement in the order for that particular child to be included. Thank you very much.
Okay, sorry for calling you the perpetrator. All right, we are having here, thanks for the response. Lebu is saying that I was happy to hear in one of the other webinars, the highlighting of the importance of psychological interventions, had people, all right? And I like that. He says that had people. Thank you for that. Most of these child perpetrators have been violated or witnessed the same happening, all right? So then meaning that is vicarious trauma, then translating into perpetration. And also says that I was also glad to see that making a child witness a GBV is also seen as abuse. On paper, all is looking like we are heading in the right direction, and I hope it will be, that is, all these changes will be implemented. All right, I hope so too. Right, we need just to join hands and have these pieces of legislation. But I would also like to say this to you, Lebu, that we have requested the key stakeholders. Actually, it's not requested. The domestic, I will talk about the Domestic Violence Amendment Act. It requires them to make then the directives, the national directives for their functionaries. And we also have here the regulations for the National Register for Sex Offenders, which also places certain responsibilities on the different stakeholders. Now, coming to the functionaries at the service points, the issue of secondary traumatization, it needs to be dealt with. And if it was possible for us to criminalize that act, I think that it's something that we would have done long time ago. But what we have done right now is to ensure that each and every set of the national directives that will be developed by the different stakeholders. I can mention just a few, that we have a DBE, the Department of Basic Education, are required to produce the DG, places a legal duty on the DG for basic education to develop the set of national directives for all the educators. And also DHET, or Department of Higher Education, must also develop their directives. Social Development must develop their directives. That must also be speaking to the issues of shelters, women in shelters, and so on. And also then GCIS as well, is required to produce the set of directives. And for GCIS, it is issues that will be talking to the electronic communication service providers and how do we manage them? Because sometimes you will find that the content that is abusive, all right, will be published on those platforms. Okay, so we need to find a way in which we are holding them accountable, people who are using those platforms to abuse their victim. So GCIS then is coming on board then to develop then the national directives that will be speaking to their functionaries as to how then they can create then that collaboration with the different electronic communication service providers that we have in the country, all right? Because we have a legislation right now that says that the court may issue an order against the electronic communication service provider to release the details of the person who actually published that content. Where did it originate? They do have that content, all right? And secondly, to also indicate, to also, to execute as well, the order that may come from the court that will be saying that remove that content from the media platform, all right? So then there are certain tariffs then that will be set for them, because they will have to be paid at some point, and for those services. And the failure to comply with an order that will be coming from the court to the electronic communication service provider will amount to a crime. So GCIS has to put together then the national directives, that will be managing that communication and that relationship, and ensuring then that they also do comply with this legislation. And the other one that will be, I think, is the Department of Health also needs then to have their national directives. So, but what is important is that each set of national directives must incorporate consequence management provisions, and there must be disciplinary measures that are taken against all of those who will be subjecting our victims to secondary traumatization or victimization where they get to the service points, and also for the non-compliance with the act, and also with the directives, all right? So it makes those provisions. So meaning that then the directives will not be acceptable, if they do not incorporate those disciplinary measures, so as to address then and eliminate the incidence of secondary traumatization at our service points. All right. All right, so I think then this is taking us then to the end of the session. I'm having another comment that is coming from Elmari. He's saying that smartphones and parents giving children the tools to commit crimes like this, as they do not educate a child. So in my opinion, parents should be held accountable. How many parents know that it's a crime to have a WhatsApp for a child under the age of 13? My opinion, this is coming then from Elmari. So I support, us holding parents accountable, because right now we have a situation of parents who are relegating their responsibility for parenting to teachers and to nannies and other people, all right? We have parents who are actually parents only by name and not by action. So we need to have these issues dealt with. And as I have said, that should we fix the family values, I tell you that we'll be able to address the issue of gender-based violence and femicide in the country, because there is absolutely no one who is born a rapist. There is absolutely no one who is born the abuser, okay? It's a learned behavior, and it starts from the home setting. It's homes that are polluting the community, all right? So it's not vice versa. It is the homes, it's people in our home settings who are actually poisoning the entire community and the society. So if we fix family values, restore family values, rehabilitate our families, and ensure that there's proper parenting, we'll be able then to bring the levels of gender-based violence and femicide to an absolute zero. All right. Is there now? I'm going to be giving you, Miss Makila. There's somebody who wants to comment. All right, Daphne, I'm giving you the opportunity to make your comment.
Thank you. Thank you very much. I think it's a very interesting topic, but I just want to add, I think a lot of has been said around reporting, and especially, what happens if you don't report. I think we also need to have different legislations in place that is already in place. If you look at Section 110 of the Children's Act currently, they mention mandatory people that has to report all types of abuse of children, which is inclusive of your sexual offenses, crimes against children. Section 305 of the very act also says failure for any of the mandatory people to report carries a maximum of a 10-year sentence for a first-time offense, and up to 20 years sentence for a second time if that person does not report. And if you look at the list of mandatory, it's a lot of people that has to report. But I can tell you now through experience, a lot of people that is on that list don't even know, one, they have to report, or the fact that they're mandatory, or that they even are in that list for that matter. So we have a lot of work when it comes to educating around these various legislations. That's one. Two, the other issue around parenting, and I think it's absolutely right, but also one needs to be aware that the Children's Act, in terms of the various types of abuse, and one of it is deliberate neglect, and deliberate neglect also talks to not supervising your child. That is deliberate neglect, and not also supervising your child's education and so forth. So to all parents accountable, in terms of not providing the support, not monitoring their children, not supervising them and their whereabouts. If you look at the Tavern, incident, as sad as that it is, there's a lot of questions raised. How do you not know your 13-year-old child is out at that time of the night? How are we holding parents accountable? It's a crime. If you are found guilty of deliberate neglect, it is a crime, and parents can be held accountable, and caregivers and so forth. And the last comment I want to make, colleagues, please, and I think it's important, Registrar, from all departments, you want to cut red tape, you want to cut the bureaucracy when you're looking at these issues. When there's duplication, please cut the duplication so that there's a streamline of where you can get the same information, that there's no duplication. But one understands, yes, you need to have, if you're zooming into sexual offenses, yes, you need to have the various, sexual offenses. But when one is vetting, make the process easier so that there's no red tape and bureaucracy, especially for the professionals. And also, in the best interest of all the various children that need to be placed, because currently you can see there's such a huge gap around the vetting process. Although it's 21 days, I can tell you now, it doesn't really happen in 21 days, for the vetting and so forth. And at the end of the day, those vulnerable children that needs to get the intervention, it's stalled and delayed and so forth. So that's just my last comment around, when we do talk about integration of different legislations, like the speaker just mentioned now, you talked about so many legislations. There should be one thing where we pull out these various legislations and put them together. We see there's no integration, and therefore we can have the best legislation, but there's failure to operationalize them on the ground. Thank you.
Okay, thanks, Daphne. Thanks for that comment. I think it is well taken by people who are here. And any response? Ntombi? The volume was low, ne? Yeah. Nam, I was barely hearing her, but I thought that I was the only one who was unable to hear. Our apologies, Daphne. I think that I should have, but then I've heard some of the part of your comment, but hopefully that people from the other side have heard you. But from our side here, the volume was quite low, all right? But then we there's also then the comment that is coming from Nediswa, who's asking, is there a way to access the material? So I hope that you are asking about the presentation. So the presentation, you can get it from, you drop in your email address here, and you'll be able to get this information, all right? It will be sent to you by the Secretariat, and the email address for the Secretariat, it is Dikweni, is Dikweni. Dikweni is spelled as DIKWENI at justice.gov.za. So you send your information there, and you'll be able then to get everything. So I think it definitely, we need to have, as we're going to be moving on to the month of August, rolling out the webinar series. As I said, that we have been requested by people that we need then to move on, because 1 month for them is not enough to have all this information. Massive changes that have been introduced, as I have said, that they've actually reconfigured the way that we are addressing issues with our laws on GBVF. The infrastructure is changing drastically. So we need then to have more and more of these. So I'm thinking that we will have to include the voice of the NPA, all right, in these issues, to talk about the challenges that they're experiencing and what are the expectations that people should be getting from them, in issues like this, all right? So we'll give you that platform when we get to the next, which we are developing. So if you can also, because if you do have my contact details, please drop it there. Now we can see Luando. Thank you so much, Luando, for reflecting the email address on the chat. All right. So please, it's there. It's on the chat. So you can get that and get all the information. Now I'm going to be passing it back to you, Ndombi, so that you give us then your parting shot.
Thank you very much. Thank you, Advocate Kambula. Colleagues, thank you so much for being part of this particular journey. You know that, as they say, the journey is much more fruitful when it is taken together. Even the fight against GBV, we can be able to conquer that when we speak from the same voice. When we see that a sexual offense is being committed against any vulnerable person, when we report that, that's when we can start or begin to see our laws coming into effect, and we can give them teeth to bite. Because when we stand by and do nothing about this, we still going to sit here, draft more laws, complain about, how far or how worse is our society. So each and every one, let's take on and then let's fight this. I know that together we can make something very much meaningful. Thank you so much for your time, and thank you for your insight and questions. And until we meet again, I would like to thank all the organizers, everyone, each one of you. Thank you very much, Advocate Kambula. Thanks a lot. That will be that. Thank you.
Thank you so much, everyone who has attended. We really appreciate your support. And we will have another one on the NRSO, because NRSO has changed it. So many changes have been introduced to this chapter. So we will need to have another session. So please take the word around. We'll be sending other invitations, and to get the second round, that will be looking deeper now into other areas of the NRSO. And I would like, and I think, what we gonna do also is to bring then a DSD and also the NRSO, so that they talk both. All right, we have that a webinar that will be bringing both of them, all right, so that they talk about the two registers and we are able then to get the differences between them. So thank you so much. Then this takes us to the end. Thank you so much. So I'm ending, closing the webinar right now. Goodbye. See you next time. All right. Thank you. Thank you.
They say I'm up that side, so.
So you need